Hello everyone, thanks for joining us. This published article aims at providing readers with an understanding of the TP audit process in Nigeria, with a focus on the dispute resolution options available to taxpayers. As the drive to increase government revenue continues in Nigeria, taxes have taken a bigger role in the generation of income to fund the national budget. TP has not been left out, as TP audits have become more common, with the FIRS attempting to conclude as many TP audits as possible. Therefore, the possibility of a taxpayer being selected for a TP audit has become significantly higher. Coupled with the technical nature of TP and the potential for huge additional tax adjustments has made TP a major focus area for taxpayers. As such, it is important that taxpayers take a proactive approach to TP audits, having in mind the end game from the start of the TP audit by evaluating the dispute resolution options. TP audits involves a detailed review of taxpayer-related party transactions to ensure compliance with the arm's length principle. The TP audit process in Nigeria typically consists of 4 phases. Phase 1, TP risk assessment and debt review. Phase 2, field audit. Phase 3, post-field audit. And Phase 4, post-audit. There are different dispute resolution options available to taxpayers. It is essential for a taxpayer to proactively review these options and come up with strategies for the audit which can significantly strengthen the taxpayer's position where a dispute occurs. There is a negotiation option which allows taxpayer and tax authority to reach a mutual agreement through dialogue, aiming to resolve TP issues amicably. Successfully resolving TP dispute through negotiation can set positive precedents, but if the negotiation results in a perceived concession by the taxpayer, it may create negative precedent for future audits in Nigeria and other jurisdictions where the group operates. It is very crucial for companies to approach negotiation from a position of strength and be well prepared with a proactive approach to ensure successful outcome and prevent potential negative precedent. The second option is the decision review panel, which involves 5 members of the FIRS, including the head of the TP department, coming together to deliberate on the issues, taking into consideration the objections from the taxpayer. However, due to the composition of the DRP, taxpayers may query the objectiveness of the panel in resolving disputes. The decision of the DRP on any issue brought before it represents the FIRS final position on such issue. The final option for resolving TP disputes is litigation, which allows taxpayers to seek redress through the court system. The Tax Appeal Tribunal, established specifically for tax-related matters, is often the starting point for these disputes. If unsatisfied with the decision of the tribunal level, taxpayers can appeal to the higher courts, ultimately reaching the Supreme Court. It is important that taxpayers usually attempt to resolve disputes through administrative channel or dispute resolution mechanism before turning to litigation. In conclusion, transfer pricing is a complex area in taxation that requires careful attention. Dealing with TP matters reactively can lead to financial and legal risk. Instead, a proactive approach is recommended when dealing with the tax authorities. Though taxpayers aim to avoid dispute during TP audits, being proactive in analyzing TP resolution options and formulating a resolution strategy is advised to handle potential challenges effectively. To read more on our articles, please visit our website and subscribe using the button below. Thank you.